Good morning, everybody. For those of you that don't know me, my name is Lisa Sweet. You would normally see Natasha Hartson in here facilitating today, but Natasha, of course, everybody from Fort McMurray knows about the current flooding situation, and Natasha is currently helping out in our Regional Emergency Coordination Center. So you're stuck with me today, and I'm filling in. So thank you all for joining us this morning. This is our fourth virtual roundtable. Today we're going to be talking about employment law. I want to just say, first of all, that I hope everybody's staying safe. And for those of you affected by the flooding, we are all thinking of you at this time. And I just wanted to say that our Wood Buffalo Economic Development team is working in collaboration with our community business support organizations. We're working hard to help support and provide information to the businesses that have been affected by the current flooding. So today I just wanted to, I'll start by introducing our speakers. So we have some associates from Bryan and Company out of Edmonton. So we have Chalene Gallagher. Chaylene is a senior associate with Bryan and Company. She's particularly focused on labor and employment matters, but maintains a broad practice including commercial litigation, wills, and estates. Chaylene handles legal claims as well as matters involving employment standards, complaints, human rights, unions, occupational health and safety, and other matters. During COVID-19, she has redirected much of her time to maintaining real-time knowledge and passing that on to her clients and her community. Then we have Liston. Liam is an associate with Bryan and Company as well. They're in Edmonton, where he maintains a corporate practice focused on mergers and acquisitions, securities, and corporate governance. Liam enjoys working with business entities of all sizes and stages. And during COVID-19, Liam has advised on the implementation of different business relief measures, including the Canada Emergency Wage Subsidy. So I just wanted to let you all know before I dive right in, you are all on mute. As you enter, you're on mute, and there will be an opportunity for questions. Our panelists today are going to each give a presentation, and then at the end there will be time for questions and answers. So you can actually put your questions in the Q&A box down at the bottom of your screen. Type those in, and then for those of you that are calling in on the phone, if you want to email your question, you can email info@choosewoodbuffalo.ca. So without further ado, I will pass it along to Chaylene.
Good morning, everybody. Thank you for having us here for this presentation today. It's really important to us at Bryan and Company to try to reach out to as many small and medium-sized businesses throughout Alberta as we can right now. We know there's a lot of conflicting information. There are a ton of questions. We're certainly keeping busy on the employment law side of things. We also know that Fort McMurray and the surrounding area has some other urgent environmental matters going on that are taking a lot of sort of immediate attention. So we appreciate your taking the time this morning. Some of what we talk about today will be helpful for that matter as well, just because this is a further business interruption for a lot of you. So take away what you will, and then we assume that you've got some really urgent things that you're dealing with. So thanks for giving us the time. One of the small disclaimers that we give at the beginning of all of these presentations is that, presumably none of you are our current clients. So what we're going to provide to you today is information, not advice. That means that we're trying to trigger you to answer certain questions. We're giving you some information on what's going on, but we're not telling you what to do for your particular circumstances. So take what we say today. We recommend that you do seek legal advice thereafter before implementing anything, and just take that with a grain of salt. Also, since this is being recorded and published, that note is really important because we won't be able to answer all questions or apply everything to your specific fact scenario. Lisa gave a little bit of information on both Liam's and my practice. So that's fine, but I wanted to round that out a little bit with some information about Bryan and Company in general, because we're not in Fort McMurray, so you might not know a lot about us. Bryan and Company is a firm of around 45 lawyers here in Edmonton. We are one office, and we keep it that way somewhat on purpose. It's very important for us to maintain a regional focus. So our focus is largely owner-operated businesses here in Alberta. That being said, we range everywhere from the small mom and pop shops to some publicly traded corporations. And, you know, we like to say that we punch a little bit higher than our weight class, and that we have appeared in all levels of court and for all of our clients. So we're kind of almost a niche office here in Edmonton, in that we're a large office, but very Alberta focused. So that gives us a unique perspective on COVID-19 and the changes that have been ongoing. We have a much more pointed Alberta focus than a lot of the national firms have. So as Lisa alluded to here, we'll save around 15 minutes at the end for questions. I'll get either Dasha or Lisa to give us a little bit of a hand signal when we get to the 15 minutes left here. Generally speaking, Liam and I have given these presentations a few times, and we're pretty decent on time, but we also won't be keeping an eye on it. So we'll try to be diligent here. I'll be presenting first, just giving the employment and labor law outline. Again, we're not going to get into crazy fact-specific scenarios. This will more be an outline to give you an idea of what you should be watching out for, where you should be asking questions, where your risks may lie, what the kind of risk pockets are during this COVID-19 time. After I'm finished, we'll go over to Liam, and he's going to give you an overview of the wage subsidy program, the CEWS. We suspect that a lot of you have already gotten some information on that topic. The CEWS program has changed really rapidly, so there is misinformation out there. It's also fairly complex. So Liam will give you that overview so that you can go from there and get some advice on how you might want to implement that. So when it comes to the employment law, I'll give you an overview of the kind of main responses that businesses have had that I've seen, the risks with them, and then the procedures in order to implement them. So when it comes to COVID-19, we obviously in Alberta got an announcement yesterday that we might be beginning a reopening strategy here. So things are going to change again, but that does sound like it's going to be a long-term process. So for now, we're going to be sticking with a fairly closed down Alberta. That carries significant repercussions for businesses, of course. I think all businesses are feeling it in different shapes and forms. So those businesses have had to generally cut costs. What we've been seeing for the most part here has come in waves. So right at the beginning, it was our dental clients. Dental offices got shut down. They didn't have a choice. They immediately laid everyone off. And this March 17th date is going to become important when I talk about layoffs. But a lot of the dental clients performed their layoffs before March 17th. So that was for sure the first wave. Second wave that we got is sort of businesses like what I presume most of yours are, not necessarily dental or professional specific, but owner operated businesses, and they started having to implement strategies as well. Then the third wave was people who had implemented strategies incorrectly. So that's when I started getting calls of people who had laid off hundreds of employees, but given none of them layoff notices. And then we're on cleanup duty. So the best bet is always to get advice before you take any steps. And I mean, again, legal advice, not just informational sessions like this, to make sure that you're doing it correctly, because cleaning it up is never a perfect solution. So the responses that we've seen businesses take, it's overwhelmingly layoffs. That has been the overwhelming majority of what my clients are doing. The second one, though, is wage and or hour reductions, and that's not insignificant. There are quite a few businesses that have taken that route. And then the third one is obviously terminations. That's a little bit less common for a couple of reasons. First of all, it's permanent, but second of all, it costs money up front, generally speaking, if you want to do it correctly. So when it comes to temporary layoffs, The layoff scheme in Alberta has changed multiple times over the past couple of months. It's everything that we can do to keep up with it. So temporary layoffs traditionally in Alberta have been a 60-day temporary layoff. One thing to keep in mind is that when you're communicating to your employees, you want to use the correct terminology. So colloquially, a lot of people have traditionally called a termination a layoff. Oh, I got laid off from my job. We're going to lay off a bunch of people. Keep in mind that in Alberta, legally, a layoff is a temporary, traditionally 60-day layoff. Now, the main change to layoffs that's occurred in Alberta has been that layoffs effective March 17th and onward that are related to COVID-19, and that's obviously not a super high bar right now, but you would have to be able to draw that connection, are extended to 120 days. So we'll deal with kind of the first common question that comes up, which is if people have already laid off and they've done it correctly on the 60-day timeline, how do they now deal with the extension to 120 days? As far as we've seen that the government has put out so far, there's no obligation to tell your employees that it's extended to 120 days under the legislation and the statute. That being said, as an employer, you do have an obligation to not mislead your employees. There is a risk there. If you do mislead them, there's a chance that you could have risk of constructive dismissal, which is something that I'll speak about in a moment here. So what we're recommending to most of our clients is to send out correspondence advising them that the layoff has been extended to 120 days and that at this time, items remain uncertain and they may have to avail themselves of that extension. Obviously, there's a lot of softening language in there. Most of the employer clients are saying something along the lines of, we hope you're doing really well. We look forward to seeing you soon. We'll continue to monitor the situation. So that's just that one first point about the layoff extension. Now, when it comes to layoffs in Alberta, there are fairly strict obligations in giving a layoff notice. It has to contain quite specific items in a layoff notice. And if you miss one of those items, the risk can be fairly significant. So if you give an improper layoff in that it doesn't have a notice at all, or it has an incorrect notice, or if it's served incorrectly on that employee, there's a chance that you've just terminated that employee by telling them not to come to work, either constructively terminated them or actually terminated them. So the risk there is fairly significant of doing an improper layoff notice. There are resources online for how to do a layoff notice. That being said, with things changing right now with the extension to 120 days, with the references to COVID-19 and the consequences in the economy, we do recommend seeking legal advice before you prepare a layoff notice because, for instance, with the extension to 120 days, the legislation hasn't actually changed. So it's awkward because you're preparing a layoff notice and you have to include pieces of the legislation in it. Those pieces refer to 60 days. So you need to make sure that you are additionally clarifying that this layoff notice is expected to last up to 120 days, even though it says 60 days in another piece of the layoff notice. So just keep in mind that there's kind of a few small obstacles that you might not think of when preparing a layoff notice that you'll want someone to catch for you. So when it comes to a temporary layoff in Alberta, at the expiry of that layoff, used to be the 61st day, now the 121st day, that employee is deemed terminated. So you don't have to terminate them. You don't have to do a termination letter. It has just occurred. So at that time, you are obligated to give them anything you would on a termination, which includes their statutory entitlements under the Employment Standards Code. So that's that range of anywhere from 1 to 8 weeks, plus any common law pay in lieu of notice that you would have to pay them under what's called the common law in Alberta. So that's, people use the rough rule of thumb of a month per year of service. That's not quite correct. It's a little bit more complex than that, but that's what I'm referring to there, that pay over and above what's in the code. So at that deemed termination, at the end of the layoff, it's just as though you terminated that person without cause if you fail to recall them correctly. So when we got the announcement yesterday that some businesses were reopening sooner rather than later, the recall notice issue became huge for us immediately. So we were instantly drafting recall notices because we can think of quite a few clients who will be able to recall right away. I spoke about dentists before. They're going to be getting back up and running. There are specific requirements for a recall notice as well. It's much less than the layoff notice, but it does have a few tips and tricks in it also, because if you fail to serve it correctly, the recall notice, you could get yourself into pretty hot water if you try to terminate thereafter. And also the recall notice has strange timelines. So when you give a recall notice, you have to have the employee, or the employee rather, has to return to work within 7 days, but it doesn't give an actual day for that. So there's a tricky way to word it to say you must return within 7 days. Please contact us to talk about the details of that return, et cetera, et cetera, et cetera. So you can get yourself certainty, even though that within 7 days is a very uncertain timeline. So you just want to be a little bit careful with that recall as well. The next thing that a lot of our employers are doing is wage reductions. That's fairly common. People have all sorts of different ideas about whether it's a 16% wage reduction or a 10% wage reduction that results in constructive dismissal risk. Long story short, in Alberta, it's a little bit of a moving target. So when we talk to our clients about wage reductions and constructive dismissal, we usually say you're getting into the danger zone around that 12 to 15%. Generally speaking, a wage reduction of less than 10% is fairly low risk. So you can usually do it as an employer without having a lot of risk that the employee is going to say they've been constructively dismissed. Anything over that, you start to get into that sort of risk profile of constructive dismissal. So generally speaking, you can reduce that by two main ways. One of those ways is to give a lot of notice of the reduction. So we're talking about the same-ish amount of notice you would have to give for a termination. And that doesn't actually get rid of the risk. It just reduces the damages in the event that someone claims constructive dismissal. The second way is to have it be voluntarily consented to. So this is the route most of our clients are going. So to kind of give you a practical overview of what that looks like, we speak with our clients about messaging and how to message it so that it's actually voluntary on paper, as opposed to saying, take this 40% wage reduction or we'll have to lay you off. That is, of course, not voluntary. So we speak a lot with our clients about how to use their, power in a really responsible way to make it sound actually voluntary. That goes all the way up to me giving my clients actual scripts for these conversations. Once you do that, you want evidence that it was consented to voluntarily. So we've been using a wage and or hour reduction agreement that the employees actually sign off on, saying that they took it voluntarily. You don't necessarily want to contract into sunset clause there if you can avoid it. So the employees are going to want to say, well, how long is this going to last? Are we going to be 3 months, 4 months? What's the plan here? As an employer, if you can avoid giving that timeline, that's better, because your employees can hold you to it, obviously. So usually what we end up doing is something along the lines of, this is intended to be temporary. We will continue to monitor the situation. So kind of keeping it in that gray area protects you a little bit better there. So that's with either a wage or salary, or a wage or hour reduction. And the obvious next question is, well, can I do both? Can I tell my employees that they're now on a 3-day work week as opposed to a 5-day work week, and that therefore they're reduced 40%? For sure. You still got the same risks there of constructive dismissal, but that is one of the reductions that you can work with. Otherwise, you could just have a straight wage reduction where you're rolling everyone back 20%. I've had significant number of clients in the last couple of weeks say that they're reducing everyone's vacation entitlement by a week, or they're capping vacation at a number that they didn't have before. So there's all sorts of steps that employers are taking in order to reduce labor costs. All of those steps, you kind of put the remuneration or the money that the employee is getting into their pockets, and you consider what you're doing to reduce it, and whether it's reducing profit share, hours, wages, whatever the case may be. If that reduction amounts to kind of that 12 to 15% or more of their pot that they get every year, that's when you get into that risk. That's where you really want to get legal advice. So that's reductions. Then the last thing is just terminations. So generally speaking, of course, these are terminations without cause because they're due to COVID and the downturn, the price of oil, of course. So those terminations, you will generally want to seek legal advice on if you can. I won't get into termination law in general because it's a little bit less timely and also takes a bit more time. But when it comes to a termination, if we get one into our office, we'll generally do a legal termination letter setting out the amount within the Employment Standards Code that the employer is obligated to give to the employee. We'll do an offer letter for anything over and above that the employer is offering, and that goes toward that common law entitlement. And then we'll do a release, because if you've offered or paid something over and above the Employment Standards Code amount, you are entitled to request a release from that employee so that you don't have to worry about this for the next 2 years for them to sue you for for wrongful dismissal, sorry. So that's kind of the three main responses that we're seeing from our employer clients: layoffs, reductions, and terminations. Terminations have been fairly rare, but I will say I'm starting to see a little bit more of them. Part of the reason that I think that's happening is because employers have started to take stock of where they want to be long term. And as companies have a little bit less revenue coming in, they're starting to cut the people that they perhaps would have terminated later on anyways. They're not floating people as long as they would. So we are starting to see a few more plans that include permanent terminations without cause. The one thing to note on terminations, and it's just one COVID specific factor, is that right now, because of COVID-19, it's a lot more difficult for those employees to find new employment, COVID-19 and the economic downturn. So that actually increases your risk factor as an employer. So you'll want to make sure that you're taking stock of that when you're calculating how much and whether you're going to make an offer in exchange for a release, because your exposure could be more significant right now. I've mentioned constructive dismissal a few times during this, so I'll just get into a very brief overview of what that means. Essentially, constructive dismissal is when an employer has unilaterally changed a term or terms of the employment agreement to such an extent that the employee can treat it as an intention to not be bound by the employment agreement anymore. And when I say employment agreement, I mean written, verbal, just the fact that they work for you. So if you've traditionally been paying someone $100,000 a year and then you just start paying them $60,000 a year, the employee could potentially treat that as a constructive dismissal, because you have now unilaterally, as an employer, on your own, breached a term of the employment agreement. So when you constructively dismiss someone, there's risk that they could claim constructive dismissal. And then your obligation at that point, if they successfully claim constructive dismissal, is the same as a termination. So you've got the Employment Standards Code risk and the common law risk. Again, that rough rule of thumb is a month per year of service, with some exceptions. It's not quite that simple. So that risk could, of course, be immense if you have fairly senior employees, if you have long tenures, and it's increased again by COVID-19 right now. So that's your constructive dismissal. And I'll just repeat, before I said there's two ways to avoid or reduce that risk, one of which is notice, because you're giving that notice that you would have to of a termination, like working notice. And the other one is having them voluntarily consent to the reduction. So then it's not unilateral, so it wouldn't be constructive dismissal risk as much. And then the next thing that I just wanted to touch on is occupational health and safety. So this could fill its own 1-hour presentation. And I'm sure you're all fairly well versed in it, given the industries that operate in your area. But when it comes to occupational health and safety, you as an employer have an obligation to keep your employees and anyone else on the work site as safe as reasonably practicable. So that means that you have to demonstrate that you are educating yourself, and taking steps to make sure that people are safe and healthy. Obviously, that's a huge problem with COVID-19. So there are certain obligations during this pandemic that we haven't seen before. Some employees may have obligations to allow people to work from home if they reasonably can. They may have obligations to set up a shift schedule if they reasonably can, and if that's what's required to keep people safe. I mean, we're all getting kind of a practical hands-on education with occupational health and safety with different warehouses like the Cargill plant. That's been the hot button topic right now. And the question there is, well, did the employer do enough to keep the employees as safe and healthy as is reasonably practicable? So try to avoid that question being asked of your workplace. One of the best ways to avoid that question being asked and to avoid an occupational health and safety complaint is to stay in contact with your employees. So even just the barest communications of saying, listen, we've doubled cleaning staff. There are hand sanitizers throughout the office. Please, this is possibly your best defense against occupational health and safety, is the phrase, please let us know if you have any concerns. Because then the employees feel like they're being heard. And you know, some of their recommendations may be great and may be things that you can easily implement. So that's that occupational health and safety kind of strategy. One of the things to keep in mind is that occupational health and safety risks can be massive. So in the Occupational Health and Safety Act, there are criminal repercussions for breaching occupational health and safety, and the fines are fairly significant as well. So for a lot of our clients, that's sort of the last thing they think about, but it shouldn't be. You want to make sure to educate yourself on what you should be doing. And just one quick comment in light of the press release yesterday, this is going to become even more a forefront thought for our doing so in a reasonably healthy and safe manner, because you still have that occupational health and safety obligation. And then just touching on EI, employment insurance, and the CERB, things have been changing really rapidly. I'll make just one overarching comment. As an employer, if you're taking steps such as layoffs, terminations, wage reductions, you'll want to avoid telling your employees too much about their entitlements to benefit programs from the government. The reason I say that is because you want to avoid making a promise and then them not being eligible. Because in the event that you accidentally do that, you could be held to that promise down the road. So we like our employer clients to encourage their employees to seek out benefits and to figure out what programs are right for them. But we want to make sure that they're not making any promises that could bite them down the road. The CERB has largely eclipsed EI for now. So for instance, even if I was to try to make an EI application, it gets automatically rerouted to a CERB application. I'm not going to run through the specific requirements for eligibility for CERB because, first of all, as an employer, you shouldn't necessarily be advising your employees on it anyways. But more importantly, it's actually really well laid out on the government websites, which isn't always the case. But for CERB, they've got a pretty good website for it. If anyone wants more information about that and asks it in a question and answer, I'm happy to spend more time on it. But essentially what's going on there is that if employees have been completely or virtually reduced to not being able to make a wage, they can apply to the CERB and get paid there. It's that roughly $2,000 a month entitlement. And then I'm not sure where I'm at for time here, but I will probably leave the employment law overview at that and pass it off to Liam for the wage subsidy portion. And then I'll get back on here when it's time for questions.
Thank you, Chaylene. Liam, you have about 15 minutes.
Perfect. Thank you. So just briefly, like we previously talked about, my practice is generally focused on corporate M&A work, but obviously given the current circumstances, Lots of our owner-operator clients, like Chaylene mentioned, are dealing with two main problems, which is accessing capital, as well as determining how to allocate that capital, whether that's to other sorts of working capital aside from employee costs, or to their employees, whether that's in the form of government aid programs or direct compensation. So I just want to quickly touch on a couple of the programs that have been implemented, whether that's by private institutions in Alberta, federal, provincial governments, to provide further access to capital or easier access to capital for small businesses right now. The first one would be the CBA loan, which is the $40,000 loan that businesses can access if you have a particular range of payroll. I believe last time I checked, that was 20,000 on the low end to 1.5 on the high end. And so that's a $40,000 loan, which 10,000 can become forgivable if you are able to meet certain conditions. There's corporate income tax deferrals, meaning most taxes paid from March to August have now been deferred both at the provincial and federal levels. The Workers' Compensation Board premium relief program has also been rolled out. So depending on your WCB premiums, there's some aid there where you can push your premiums a year, and up to 50% of those premiums can actually be forgiven. So there's obviously more eligibility criteria than just that. The last thing I would mention is what's been termed the Business Credit Availability Program. So that's an effort by Export Development Canada and Business Development Canada to make capital available at relatively low rates to businesses of different sizes. And again, there's different thresholds, but I've been able to help clients access capital through both of those programs. They're relatively easy to use and quick to get going. That said, there are some strenuous requirements as far as guaranteeing and stuff like that. So those are kind of the other programs that are out there right now, aside from the one we're going to talk about for the rest of this, which is geared towards the Canadian Emergency Wage Subsidy. Now, just for clarification, there's two wage subsidy programs out there right now. So when this all started, the initial plan was the provision by federal government of the ability for owner-operated companies to access approximately 10% of remittances, basically. That was the idea, was that depending on the amount of remittances you paid, you had access to some funds. That has obviously been supplemented by this 75%, or what has been termed the 75% wage subsidy, which is the wider ranging program that was officially passed into legislation in early April. So that's the first thing, is to ensure we're talking about the larger subsidy program here. Now, that being said, there are some interplays between the two. I'm not sure that it makes the most sense to talk about them here because there's not a ton of overlap, but I would caution you to ensure that you're looking at the right program as we talk about this. The second thing that I want to deal with is kind of the colloquial or newsworthy title that this is a $58,000 subsidy. That seems to be the popular rhetoric around it, which is, hey, this entitles employers to $58,000 per employee, which is a great tagline, but unfortunately the mechanics of the program, that's not entirely accurate. So the $58,000 number that has been presented in the media is a reflection of if you were entitled to the maximum $847 weekly subsidy for an employee for an entire year, which obviously this program is not going to exist for an entire year. At least currently that is not the case. It's only contemplated as existing for 3 months as we speak today. So I want to ensure that nobody here is banking on the fact that they're going to be entitled to $58,000 per employee. That's just simply not the case. Generally speaking, if you were entitled to the maximum amount of subsidy for an employee for the range of the program as it exists today, I believe the numbers work out to about $10,000 per employee. So that's if you butt it up against the $847 maximum for the length of the program as it exists today. Basically, I just want to touch on the kind of 3 or 4 main considerations that you should be making as an employer when you're looking at this program. Obviously, working through the legislation and the calculations it's far too complex to do over video or in a short period of time, but there are some overarching categories that I think you should turn your minds to. The first is, are you as an employer eligible? Now, this is generally an easy one to meet. The legislation contemplates lots of different corporate structures, whether that's partnerships, closely held corporations, any taxable corporate structure for the most part is going to be eligible. There are some carve-outs in there, which, it's not completely clear how trusts are going to be treated, and it's still not completely clear how certain types of partnerships are going to be treated. But that being said, for the most part, your employer status will be sufficient. The one caveat I would say to that is, to be eligible, you have to have had a payroll number on March 15th. So that has actually turned out to be a burden for some individuals who run sole proprietorship, stuff like that. If they didn't have a payroll number on March 15th, that becomes a problem for you in applying for this program. The next thing I wanted to touch on was the revenue decrease. So this has changed over the life of the program as well. But when the legislation came out, it was determined that you basically are doing a comparative analysis of your revenue. And so they've offered 2 time frames for you to do that. You can compare your revenue for, we'll refer to it as March, April, or May, even though it starts March 15th to April 15th. So you can compare March, April, or May to the previous year. So March 2020 to March 2019, or instead you can compare it to the average of January and February 2020. So when you're trying to measure your revenue decrease, and we'll talk about the thresholds in a second, you have to pick whether you're going to compare to the previous year's month or to the average of January, February of this year. Now, this was put in place because certain entities didn't exist last year, volatile industries, seasonal industries, stuff like that. So this is meant to address that. And, if for whatever reason you had, a large project last year where, comparing to that month last year wouldn't be beneficial to you, you can compare to January and February of this month. Now, in terms of thresholds, the threshold for the March period is 15%. So you need to see a 15% decline. The threshold for the other 2 periods, the one beginning in the middle of April and the one beginning in the middle of May, are 30%. So you need to see that 15% decline as compared to either the average or the previous year for March, 30% for the other 2. I'm going to further caveat that by saying, if you become eligible for one of the periods under the program, you automatically become eligible for the next period. So if you suffer the requisite 15% decline in March, whether that's compared to last year or whether that's compared to January, February, you automatically qualify for that March period and for the next one, even if you don't get to the 30% that would otherwise be required. So that's something to take into consideration. We're seeing lots of people who suffered the 15% decline in March, probably didn't get to 30%, but are still going to be entitled to that subsidy during that time because they qualify for the first period. The next large-scale consideration is whether the employee that you want to claim the subsidy for is, in fact, an eligible employee. And so basically what that means is they have to have been employed by you during the time frame that you were applying for the subsidy, and they can't have been without employment or payment from you for 14 days or more during that period. And this will become important in a second and ties into Chalene's comments about layoffs and stuff like that. The last thing I want to touch on is the remuneration amount to which you become entitled. And so this gets a little bit more complicated, but basically there's a formula set out in the legislation which compares pre-COVID-19 wages, the current amount you're paying the employee, and 75% of those two amounts, and tracks it through some calculations and spits out a number up to $847. So importantly, when we're looking at the salary that you're paying an employee on which you calculate your subsidy entitlement, what we're talking about is any taxable benefit that you give to that employee. Okay, so it's not necessarily only just salary. There's certain other taxable benefits that you provide to employees. And so basically, I want you to have in your mind that if I'm paying remittances for it, that counts as part of their remuneration and should go into my calculation. For this particular piece, again, I'm not necessarily always the most confident in the materials that the government publishes for use of ease, but they've actually published a great spreadsheet on their website where you can spit in employee wage pre-COVID-19 currently, and it will actually do all the calculations for you and get you very close to the amount to which you're entitled. There are some intricacies here in that the amount to which you become entitled gets ground by things like any amounts that you claimed under the 10% program and some other items like that. But I think for the purposes of today, that's the way to think of it is I want to make sure that my employer or I as an employer are eligible. I want to make sure that I've suffered the requisite decrease in revenue. I want to make sure that the employee for which I want to claim the subsidy is an eligible employee, and I want to make sure that I have a good handle on what I'm going to be entitled to as a result of that. And so just quickly before we move to questions, I want to touch on one thing which has recently come up, which is the piece I spoke about in terms of an employee not being without pay for 14 days during a particular period. So it's recently been confirmed that you can retroactively pay an employee, and that will make them eligible for the subsidy. So put another way, if on March 15th, all of this came to light and I said, geez, I'm not going to be able to afford to pay this particular employee, you lay them off, and on March 30th, a lot of information became available and you said, hey, maybe I could have been able to support that employee for those 2 weeks, where you otherwise would be ineligible because they've been without pay from you for 15 days, striking off that qualification, you can actually now go back and pay them for those 2 weeks and use that to claim them as an eligible employee and get the subsidy for that time period. So it ties in with some respects to what Chaylene was talking about, and it's certainly a consideration when you're laying off employees as to whether you will be able to claim the subsidy for them or not. The second thing that is a very common question that we're getting is non-arm's length dealings. So I'm an owner operator, I pull some of my money from my company through dividends, but I also pay myself a salary. Can I claim the subsidy for that amount? The answer to that is yes. So if you're paying yourself a salary before March 15th, the way that the calculation is structured is that you will be entitled to approximately 75% of that salary up to the $847 limit. Just to close that off, a lot of people are saying, hey, well, I've got a closely held family company, my niece or my daughter or somebody isn't able to access work right now, so I can hire them on and pay them salary and claim the subsidy for that. The way that the calculation is structured is that non-arm's length employee has to have been working for you before March 15th. So if you run into the situation where you're contemplating that, just be aware that technically through the calculation, they would get assigned a value of 0, and you can't claim for that, which is another common question that we are running into. So I'll leave it there because I see we're at about 15 minutes for questions. And thank you for having us.
Okay, thank you. Thank you so much. And so again, if you have a question, you can type it in the Q&A box because you are all on mute, or you can email info@choosewoodbuffalo.ca. Before we go into questions, I just want to let you know that everyone can find a copy of the relaunch strategy on the Government of Alberta's website. So it's alberta.ca/external/COVID-19 Alberta Relaunch Strategy. If anybody can go into the chat there, you can see that link, and perhaps Darshana, we can email that out to the participants following this session. So the first question we have is regarding franchisers. So is there anything, so a franchise in town, a local franchise, the restaurant, they were told to close their franchise. Is this, and it was done on March 18th. So can either of you speak to, is there anything specific around those franchises that were told to close? Anything around that they need to know?
So as far as employment law is concerned, they're still likely your employees. Every franchise agreement is different, but in most of the ones that we deal with, those are still employed by the corporation over which you have control. So all of the obligations that I spoke about, you're still covered by that. The only thing that's a little bit different is that you were instructed by another entity to close. So potentially you could fall within, say, the unforeseeable circumstances under layoff notices, where you don't have to give 1 or 2 weeks notice of the layoff. You can do the layoff immediately. That would perhaps affect that. When it comes, though, to your risk assessment and potential damages under constructive dismissal or a termination, the courts so far in all of Alberta's jurisprudence haven't really taken that into account.
Okay, thank you. The next one is businesses that are now impacted by the flood on top of COVID-19 situation. So is there any additional issues that businesses should be aware of, or anything that they should know regarding laying off employees around that?
Yeah, so that is obviously a compounding issue for you guys, and I'm sure it's thrown a whole other wrench into this. From a law perspective right now, as far as I can tell off the top of my head, the only caution I would put to you is to ensure that everything you're sending to employees addresses the actual issues. And the reason I say that is because currently, if you send out a layoff notice saying that you're laying off because of the flood, you may not be able to avail yourself of that 120-day extension because they've explicitly referred to COVID-19 in that. So if you're laying off an employee because of the flood compounded with COVID-19, you want to make sure that's clear. So otherwise, the flood hasn't really changed much. And most of the rules and legislation that have come out as a result of COVID-19 don't specifically refer to it having to be because of COVID-19, but that one does. So just be cautious there.
Thank you. This one's around recall. So in the with a restaurant, that shifts may not occur within the 7-day time frame, especially since restaurants will only be open at 50%. Yeah. Do I recall as needed, or do I recall as so I know how many employees I have to work with?
Yeah, I was actually just talking about this with a dental client yesterday, immediately after the press release. Recall as needed would be our recommendation right now. Again, fact specific, you should talk to someone about that. But as far as we're concerned, your better bet would be to recall as needed unless you're willing to extend that 7 days as an employer. So keep in mind that everything within the Employment Standards Code is a minimum requirement. And that 7-day requirement is to protect employers. So if you as an employer are prepared to extend that 7 days, you may be able to do that, but then it just gets really fact specific and maybe a bit unwieldy. So I know that client chose to recall as needed. It just worked out a little bit better and put in that blurb that said, you know, call your supervisor at X number within the next couple of days because you must return within 7 days. So that puts it back on the employee to arrange for the shift.
Okay, thank you. The next one is for Liam. Are nonprofits and charities eligible for the business credit, and are workers we have reduced hours, not terminated, eligible for CERB?
Yeah, so the short answer is with respect to the wage subsidy in particular, nonprofits and registered charities are eligible to apply for it. I'll probably stop there because there are some complicated rules in terms of calculating their revenue drop, in terms of whether or not you include grants or contributions from provincial or federal government, stuff like that. But in terms of whether you are an eligible employer for that first step, quote unquote, a registered nonprofit or charity is, and so you can avail yourselves of that. With respect to the CERB question, I don't know, Chay, do you have anything to comment on that?
Yeah, I can hop in on that. So if you're reducing your employees' hours such that they're making less than $1,000, maybe. If you're reducing them such that they're still making more than $1,000, no, probably not. So one thing that I will mention is if you're an employer, and this is coming up a lot more frequently in the last week or so, if you're an employer who has a pot of similar employees and you can't keep them all employed at say 100%, but you can keep them all at 50%, you may want to consider a work sharing program. So for that 50% wage reduction, if you apply correctly and get approved for the work sharing program, they can seek EI, not the CERB, but our old traditional EI. And then it would be an ROE that says work sharing, like it's a whole completely other program from a layoff or just a bare reduction. Now you have to apply and get approved for it, but they've, in the wake of COVID-19, streamlined the application process. They've also reduced the wait times for it, I believe. And they've also extended the length of the program. It used to be 38 weeks and now it can be 72. So if you're a business that can keep people employed, but kind of around that 40 to 60% level, you don't want to lay them off, you want to make sure that they can get EI for that reduction, work sharing is a really great option for you. You might want to look into it.
Thank you. Any advice or insight on the force majeure clause? So with COVID-19 combined with the flood, evacuation, and damage, is this something to look at?
Yeah, so this has obviously been quite a poignant topic. Unfortunately, I'm sure lots of you on this call have dealt with this previously. And for anybody who don't know, force majeure basically refers to a clause that is often included in contracts, which states that if for some reason that contract is rendered, quote unquote, unperformable by reason of an enumerated list of things, it often refers to things like an act of God, things like that. Some of them specifically reference pandemics, which has obviously been the hot topic lately. Then both parties are essentially relieved of their obligations under that contract, and nobody is liable to the other because essentially what they're saying is nobody could see this coming, or it wasn't reasonable to expect it. So to answer the question, yes, it is something you should absolutely be looking into. I suspect that whether it's leases or other contracts that your business owners are looking at in the area right now, given what's gone on there in the last few years, I suspect that there's more force majeure clauses than there were previously. So I would certainly be looking at it. One of the things that you want to be cognizant of is making sure that you can point to, hey, my business is failing directly because of the particular issue. Some of the things we run into are, for example, in a large construction project where when this all started, certain people weren't allowed to have their guys at camp. So the general contractor on a project seriously couldn't perform. It was impossible for him to perform the contract. But a lot of the subcontractors could. And so the only reason those subcontractors couldn't perform the job was because the general contractor couldn't do it himself. And so we've run into a problem where you have these force majeure clauses stacked, or the general contractor has one with a sub, but the general contractor's agreement with the owner has one. And so being able to point to, I'm being deemed unable to perform this contract specifically because of COVID or the flood, as opposed to simply, hey, I can't do it because either business is bad or somebody else failed to do something and that's affecting me. That's where the distinction gets into a bit of difficulty, but I would certainly be looking at it.
Thank you. I just want to let you know, Darshana, my internet is saying unstable, so Darshana is here to back up if needed. So with a couple of minutes left, we have some small business owner operators do not maintain a business account. They are then told by their bank that they cannot apply for the Canadian Emergency Business Account Loan. They run their business expenses through their personal accounts. Do you have any recommendations for them?
Yeah, this is a bit of a tough question, and it's something we've run into. You know, for the most part, you try and run your business accounts through a business bank account or one that's in the name of you as an employer. You know, we're not all perfect. We don't always do that. And so unfortunately, the only answer I have for you is you have to work with your bank. I understand that that's problematic and they're not always the most helpful. But I'm hopeful that in the wake of all this, they're going to be a little understanding of, you know, extending credit as much as possible. But that's unfortunately the best answer I have. So I'm sorry about that one.
Okay. Oh, somebody else have. Oh, I'm hearing feedback. So the next question is, our organization laid off employees on March 26th. Will we still be eligible to claim for period 1 of the CEWS?
Yeah, so I'm just reading here. I'm going to reference, make sure I've got the applicable time periods. So again, you have to remember the criteria for whether you can claim for that employee is that they're employed for the week that you're claiming and they haven't been without pay by you for 14 days during that period. So if you had laid employees off on March 26th, you need to ensure that if you want to claim subsidy for those employees that you've paid them retroactively for the period during which you had them laid off. So that goes back to, I'll just use the example I used previously because the dates line up a little bit easier. March 15th, you lay some people off, you get to March 30th, because that's more than 14 days, technically you would be unable to claim the subsidy for them. But if you pay them retroactively, even if it's a reduced rate, they don't even have to work, in fact. You just have to pay them. Now they become eligible and you can claim the subsidy for that amount. Now what you pay them is going to dictate the subsidy you become entitled to. But as long as they have not been without pay from you for a period of 14 days or more during the claim period, you should be able to look at getting the subsidy for them.
You're muted there, Lisa.
Sorry. Thank you. So thank you guys so much. We are at 2 minutes left, and that was kind of the last of our questions in our Q&A box. I just want to tell everybody on the that's calling in and zooming in here that we will have this session recorded. It is recorded and it will be available on our website by midweek next week. Darshana will likely email the link to you as well for those of you that have registered. For any information related to COVID-19 or the flooding, so all of the programs that Liam talked about, we have them all listed on our website, which is choosewoodbuffalo.ca. And there's a box for COVID and a box for flood situation there. And then we also have questions that you might want to get answered. You can email info@choosewoodbuffalo.ca. So that's info@choosewoodbuffalo.ca. And for anybody who has questions related to the flooding, we have opened up our 1-800 number, so our economic development 1-800 number, and that number, I'm just going to bring that up here, that number is 1-855-923-5792. 2338. So I want to again thank you to Chaylene and to Liam and to Darshana for setting this up today. The next roundtable, we will put that on our website of when that will be hosted. And we want to thank you all and have a great weekend.